And they can't prove they're going to be annihilated. They annihilate themselves. When you shoot yourself in the head financially by filing bankruptcy.
It was very fascinating to hear the plaintiff argue that Real Water had shot itself in the head by declaring bankruptcy. Quite a visual for the court.
You're now moving on, please, to document 568, AT&T's motion for partial summary judgment on plaintiff's claim for punitive damages. Document 786, the opposition thereto. Document 887 is ETT's reply. We have, okay, we have extra water. Well, sorry, I didn't say water, but water's on
I have water.
Okay, no worries, we'll make sure you're taken care of. No, we also have one water if you need it as well.
May I, Your Honor?
Sure. Go ahead, please.
Thank you, Your Honor. Valerie Rojas for Terrible Herbst. Terrible Herbst, although Your Honor just denied the motion for summary judgment on all claims, at the very least, there is no evidence, and certainly no clear and convincing evidence, that Terrible Herbst acted with a conscious disregard for the rights or safety of any of the individuals in this case, and in particular, certainly not Myles Hunwardsen, who is the only relevant party. If you look at the plaintiff's pleadings, initially it started off in support of their claims that Terrible Herbst sold Real Water, that's not disputed, and that Terrible Herbst sold some Real Water to Myles Hunwardsen, that is not disputed. That alone is insufficient to meet the standard to award punitive damages or even to allow such a claim to be provided to the jury. There's been no fraud, malice, or oppression. And in response, plaintiffs go through a number of complaints in order to create some type of fraud or oppression as to Terrible Herbst when none exists. The first that they attempt to do is argue that Terrible Herbst must have had customer complaints and that those customer complaints may have or must have been destroyed. And this is based upon, again, the 3 customer complaints from 2014 made to Real Water. Again, 2 of those were not from a Terrible Herbst station. All 3 were from Chevron. The only one that was from a Terrible Herbst station referred to some fuzziness in the water. There is no basis to assume that Terrible Herbst had those customer complaints, was copied on them, or had any knowledge of them, and then somehow destroyed them. So what the plaintiffs do next is they came up with these videos and said that there must be some videos that have been destroyed. But there's no evidence of those videos ever being in the possession of Terrible Herbst or ever being displayed on a Terrible Herbst digital monitor at a gas pump. So this fallacy that there's been some destruction of evidence because of these videos they located through the archives of Real Water is insufficient. I mean, there's no evidence to say that Terrible Herbst even had those videos, let alone destroyed them. And it makes sense. They predate 2013. They're not even in this time frame that we're talking about. That's years ago, Your Honor. As to this false claim that 3 times Terrible Herbst did not have any communications with Real Water in 2018 through 2020. That's not accurate. There was a direct question, an interrogatory about the years 2018, 2019, and 2020. There's been no evidence that there's been a written communication or verbal communication. Plaintiffs would like to rely on this gentleman who was deposed, and we would object to any of that testimony coming in, as it's irrelevant, wasn't disclosed in this case, and isn't in as part of this motion. It's not in the record. What we have is the testimony from Terrible Herbst witnesses, specifically saying what efforts they made to search for records and found none. That doesn't necessarily mean somebody has destroyed evidence, as plaintiffs would like to claim. At one point, they say there must have been an agreement. There must have been an agreement between Real Water and Terrible Herbst. There has never been an agreement between Terrible Herbst and Real Water. The agreement was not even in writing with the distributor, Nevada Beverage, for Terrible Herbst. Real Water didn't get purchased directly by Terrible Herbst from Real Water. They went through Nevada Beverage. On page 14, the plaintiffs in their opposition say that all of this indicates the strongest possible inference that Terrible's has continuously run Real Water on its ads on its gas pumps for a decade from 2011 to 2020. And we don't have any evidence of that. We have a coupon from 2020 that ran for 2 months along with other beverages being offered when somebody fills up. You press the button. If you select Real Water, a coupon spits out. If you select Bud Light, a coupon comes out. If you select the tea that was offered, a coupon comes out. That doesn't mean that Terrible Herbst was the marketing arm of Real Water for decades, and that therefore there must be some agreement that is somehow being hidden, that couldn't even be located in Real Water's archives. So all of this is being made up as we've gone through this case. First, we had to deal with the commercials or the videos. Next came these customer complaints. But none of this shows that Terrible Herbst acted with a conscious disregard for the rights or safety of Mr. Hunwardsen. They attempt to fabricate that by using Dr. Hutt's testimony concerning what we call the gold standard. What Dr. Hutt testified to, and that's plaintiff's standard of care expert on food safety, is that because Costco was auditing, they have set the gold standard. That's her testimony, Your Honor. That is not a standard of care. She certainly didn't talk about Terrible Herbst. She was talking about Costco, which is an entirely different entity. That is irrelevant. Costco undertook a duty to audit Real Water because they were directly purchasing, and that's part of their program. Costco did not stop purchasing Real Water because of some bad audit. That audit was corrected, and they continued purchasing Real Water. It was only when their own branded water overtook the purchase of all other waters that they then replaced Real Water and just started selling their own. So it's incorrect to say that Costco recognized some problem and therefore stopped using Real Water, and therefore if Terrible Herbst had recognized the problem or learned of Costco's audits, then Terrible Herbst would have stopped selling retail bottles. That's too far of a jump. Even with Costco's audit, if there had been an audit, the evidence shows they get an opportunity to correct, and it was corrected in this case. So with that, Your Honor, I would say there is no clear and convincing evidence. Even if this case goes to the jury as it is, it certainly shouldn't be submitted to the jury as the claim for punitive damages. There's simply no clear and convincing evidence of a conscious disregard for Mr. Hunwardsen's safety here. Thank you.
Counsel in opposition?
Yes, Your Honor. Your Honor, basically we made 3 arguments. One was a 56F argument, 2 was the argument about the prior complaints, and 3 was an argument based on the standard of care to do third-party audits. Starting with the first point, I think it's pretty obvious we're not playing with the full deck here. We have a business plan saying that Terrible Herbst ran videos on all 100 of their stores, specifically says that. And Terrible's claims that there was never once a video ever run in any of their stores. We have a document from Terrible's that they admit is authentic, where they ran this 2020 ad. They admit they ran the ad, where they're giving away a free bottle of water that's being paid for by Real Water. It's not being paid for by Terrible Herbst, okay? And so they're telling the court that they ran that kind of program for 2 months. And this is a company that's selling 200,000 bottles a year in 2019 and 2020. They are, if not the largest seller of real water in terms of retail bottles. Well, I will say they're the largest because by way of comparison, the Whole Foods up in Reno, in Mr. Haley's case, I think they sold 350 bottles in the whole year. And Terrible Herbst is selling 200,000. So anyway, we have this company selling this type of quantity of product, running this sophisticated campaign where you've got to push the button, get the coupon, go back in the store, get your free bottle. You know, and they're saying that this is immaculate conception, that this just came out of nowhere, that they had no communications whatsoever with Real Water about this. I mean, that is just really hard to believe on its face, Your Honor. And counsel keeps saying there's no evidence. Yeah, there's going to be a lot of evidence when Mr. Randolph takes the stand. But in any event, it's pretty obvious Terrible's has not given us everything. First of all, there's no dispute that they haven't given us the customer complaints because they destroyed everything prior to 2020. So for them to stand up and say, oh, there's no customer complaints, how do they know that? They destroyed them all, Your Honor. They destroyed all of them. You know, they got notice of this outbreak in March 2021, and yet they destroyed everything from 2019. I mean, you know, that just wasn't appropriate. But what we do have 3 customer complaints. And the first one is the one that she refers to as saying fuzzy. When you take a look at the investigative report by the Real Water investigator, he says there was oil. That is the term he uses, oil, O-I-L. The customer said there's a fuzzy-like substance in the bottom of the water, but when they investigated, they found there was oil. That's the one they admit getting. Okay, so they had one complaint that they admit getting about oil. The other 2, they claim that, oh, that's not our Chevron, that's some other Chevron. Well, like I said yesterday, they have offered no proof whatsoever that Chevron, the standalone Chevrons, were distributors of Real Water. There's no proof offered of that. So they want the court to assume that without proof. At a minimum, that's an issue of fact, Your Honor, because Chevron is not, on any document that I've seen from the Real Water production as a distributor, it's not listed on the Nevada Beverage list of retailers that they're distributing to. So how they can claim that they know that in 2014 Chevron was selling Real Water is beyond me. Now let's take a look at the two other stores. And they hate these 2 stores because these 2 complaints say gasoline-like substance. The first one says that specifically, and then the second one says that in the investigative notes, another complaint about a gasoline-like substance. Okay. What better notice could you have in a case where they put rocket fuel, hydrazine, in water than that there was fuel, gasoline-like substance in the water? What stronger notice could you have than oil, gasoline, gasoline? What more do you want? And so we've cited cases in the opposition, punitive damages cases where the courts have held one complaint in and of itself is sufficient for a conscious disregard standard to create an issue of fact. This case, we have 3. Now, they dispute the 2, and they say, oh, that wasn't our store in 2014. Well, Your Honor, we've identified the stores, and we took pictures from them, and we've come to find out that the one store didn't even exist in 2014. And the way we did that is we went back on Google Maps and took pictures, and it's just desert. So it couldn't have been this store that they're saying it was. It had to be another store. And it had to be a store selling Real Water. And the only one in town, other than the standalone Chevrons, that are selling Real Water is Terrible Herbst. So that creates at least a factual inference that connects the second and third complaint and an issue of fact as to whether they got it or not. Now let's go to the other prong of the punitive damages case, the third-party audits. Since the early 2000s, it has been the practice of all the major retail chains to require third-party audits. You know, people like Costco are not just going to let you sell stuff in their store if someone is not at least going to the manufacturing facility once a year and take a look at it. So Costco does it, Whole Foods does it for the branded, not the non-branded product. Safeway does it, Vons does it, we have others set forth. We've got the testimony from the Whole Foods guy saying that that's the ideal, that's the gold standard. We have Dr. Hutt, and this is not something new, early 2000. This is when this started happening. So what would they have found? What would they have found if they had required this? And it doesn't cost you anything. They make Real Water pay for these audits, okay? It doesn't cost Terrible Herbst 1 cent to require a third-party audit. Doesn't cost them anything to ask Real Water to give them third-party audits than other people, like Costco, because it's pretty well known that Costco requires third-party audits. But this is the third-party audit. Shane, can I have that up real quick? I'm going to be really quick on this because I know I talk too much. Your Honor, this is the audit that was done in December 2018. That is 8 or 9 months before Mr. Hunwardsen's injury. So this is the audit that was done. You see the score there? It's 82.4%. That was a fail. And more importantly, Shane, can we get to the 10 parts real quick? So these are what are called the HACCP. Keep going, it's in section 5, I believe. This is what's called the HACCP section. Yeah, section 3, I'm sorry. And so they went through the HACCP section, and HACCP is a quality assurance program developed by NASA as part of the Apollo mission. And that's developed into a program that's used by retail all over. Everybody uses HACCP to try to ensure quality control. So this is the audit. So this is where they failed. Quality control. No, 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 no. 0, 0, 0. I mean, we took Mr. Pham's deposition, I mentioned him earlier. He said this is the worst NSF audit he's ever seen. We took Mr. Heidel's deposition, he's one of the experts retained by Milwaukee. Worst NSF audit he's ever seen. Okay, Shane, let's go to the last part real quick. So what do they say in this audit? This is the conclusion. Quote, there was no qualified individual to provide a level of competency necessary for production of clean and safe product. They did not, the auditor went in, inspected Real Water, and found that they didn't have anyone at that plant that could make a safe and clean product. And this was in December 2018. So this is what Terrible Herbst would have known if they had either required a third-party audit on the industry practice or just asked for other audits that other people are doing. So our position is that they have consciously disregarded an industry practice. And that in and of itself, I think we cited 5 cases on this point, where there's an industry practice and you don't follow it, that subjects you to punitive damages. Your Honor, I think I'm probably over my time, unless the court has a question.
I do not. Thank you so much. Counsel for Terribles? Last word before I get there. Real Water, I did not see that you had.
Thank you, Your Honor. No position from Real Water.
Appreciate it. Thanks so much. Go ahead, Counsel. Last word.
Your Honor, counsel made a comment about the customer complaints and what better or stronger notice do you want? But those complaints again were made to Real Water, not Terrible Herbst. Those complaints related to complaints from 2 chevrons not owned by Terrible Herbst. Those complaints were all from 2014. Those do not relate to what occurred in 2018 or 2019 when Mr. Hunwardsen was getting sick. As to plaintiff's contention on the audits, as he admitted, the NSF audit was considered by everyone, including plaintiff's own expert, to be the gold standard, not the standard of care. There was no conscious disregard. There's no statute or regulation or other compliance matter that plaintiffs can point to that Terrible Herbst did not comply with. What they're pointing to is Costco's audits and saying, look, if they would have audited, they would have found what Costco did. And what did Costco do? Costco allowed the Real Water folks to correct their situation and continued to purchase real water from him. But even more than that, the assumption here is incorrect. And the assumption is that if Terrible Herbst would have audited, they would have found some hydrazine. There's nobody was even looking for hydrazine. The NSF audit was not pertaining to what's in the, there's hydrazine in the water. Nobody would have known that, even with the best of audits, because nobody was looking for that back in that time frame. So this whole contention that, or this whole picture, that there's some evidence out there that Terrible Herbst has destroyed and that Terrible Herbst has consciously disregarded some industry standard is simply false. There is just no clear and convincing evidence to allow this case to go to a jury. There's no clear and convincing evidence of malice, fraud, or a conscious disregard for the rights of Mr. Hunwardsen. And with that, I'll submit, Your Honor.
Appreciate it. I do have one quick question. Exhibits 8 and 10, right, attached to plaintiff's opposition. Business plan, right? Right. And the two aspects, right, so it's the real water document, like I said, was dated October 28, 2008, on pages 9/10 of their opposition, as well as the excerpt from the business plan on page 10 of the opposition, which references it as Exhibit 10. I'm hearing what you're saying, but you said that there was no evidence, but isn't that a factual dispute as to whether or not the real water documents accurately reflect what really was and was not going on with regards to Terrible Herbst, or how does one get around those documents?
Well, even if we were to assume there were some videos being played in 2010, 2011, 2012, that's not the video that Mr. Hunwardsen saw. There's no indication that those videos are in, or were in the possession of Terrible Herbst and is somehow destroyed. That is a statement in a business plan that nobody knows anything about to this point. Nobody has testified about that. When Real Water's witness was asked about Terrible Herbst, he had no clue. He had no clue about Terrible Herbst. Meaning, this isn't some great marketing arm of Real Water, that's a fallacy. That is something that the plaintiffs would like to create by throwing everything against the wall and seeing what sticks.
I appreciate that. That's another question. Thank you so much. Okay. With regards to document 568, ETT's motion for partial summary judgment number 2 on plaintiff's claim for punitive damages, the court denies it without prejudice. The court finds there's material issues of fact. Those material issues of fact include but are not limited to, it's disputed what actually was marketed or not marketed by Terrible Herbst. Was marketed or not marketed during what time frames, whether they were relevant or not relevant. Material issue of fact dispute is actually what notice Terrible Herbst had, referencing the Exhibit 8 and Exhibit 10 the court asked the question about. There's a dispute between documents that have been provided in this case from Real Water versus the affidavits/declarations of Terrible Herbst executives. And then when the court takes actually those executives, and a statement I do not recall does not mean that it is, that it did not exist. And so the court has to, with the standards under 56, rule that, right, in favor of plaintiff. And the court also looks at there's a dispute, as stated, with regards to who those complaints were made to and what knowledge Real Water provided to Terrible Herbst, or what knowledge Terrible Herbst would have had independently of those complaints. There's also the issue of fact of whether or not those complaints involved the Terrible Herbst property, the distinction between whether or not one of the properties actually existed in 2014 versus not. There not being any evidence provided to this court in response to the evidence in the motion for summary judgment. There was no evidence in response to set forth specifically that those locations, there was arguments that those locations were not Terrible Herbst locations. There's a disputed issue whether they were or not Terrible Herbst. When you go to all of those factors, the court, whether there's material issues of fact, and dispute about whether or not it would meet, whether or not the notice aspects and the actions of Terrible Herbst would or would not comply with A, industry standards, B, with regards to the standards which would or would not meet conscious disregard. It's enough to go to a jury, so therefore the court only utilizing, or I utilize the term enough to go to a jury, as you can appreciate, the court's only utilizing the NRCP 56 standard. NRCP 56, in light of those standards, the court has to deny the motion for claim for punitive damages. The court's going to move on to document 543, Real Water's motion to amend their answer to plaintiff's third amended complaint, document 8. Document 543, Counsel for Real Water, is that still before the court? Specifically, it was unclear about whether that one was or was not.
Yes, Your Honor.
Okay, go ahead, please.
Thank you. Your Honor, very briefly, Joel Odou on behalf of Real Water. The motion seeks to add an additional affirmative defense. The argument appears to be one as to whether or not Real Water has been annihilated, is annihilated, isn't annihilated. Plaintiffs keep shifting position on that and arguing whether or not this affirmative defense is necessary. Plaintiff's position as to whether or not they can recover punitive damages is not part of this, but that seems to be their argument. And clearly, we believe that plaintiffs are going to pursue punitive damages, and therefore this affirmative defense should be added. We don't believe whether or not it's added. We don't believe that it is necessary to have this affirmative defense to make a constitutional argument, but that argument has been raised by plaintiff, and so we're wearing a belt and suspenders to say that this affirmative defense should be added. It's really a straightforward motion, and I don't really have anything to add unless the court's got questions.
I do not. Thank you very much. Counsel for plaintiffs, would you like to respond?
Yes, Your Honor. Your Honor, first of all, the motion was not a model of clarity. They didn't say what they wanted to add. We had to dig through it, do a compare with the previous one, and then we find out they want to add this annihilation defense from the defense. First problem is there's no good cause. There is no good cause for them to add the defense at this time. That's what's required by the rule because it's coming so late. So they haven't offered any good cause as to why this couldn't have been raised earlier. I mean, clearly they knew there were punitive damages in the case because the complaint asked for punitive damage against them. Clearly they knew their financial condition because they themselves filed bankruptcy. So where is the good cause to come in at the last moment and add this annihilation defense? So let's just assume that there was good cause. Let's move on to the annihilation defense. I call it the annihilation defense because that's what the Nevada Supreme Court called it in the Ace Trucking case. In Ace Trucking, it says that this is a rare defense that can be raised if a punitive award will financially annihilate the defendant. Where they have said in multiple pleadings that they're dead already because they went into bankruptcy. They have no assets. It's a Chapter 7. It's not an 11. The punitive damages award could be $100,000, $1 million, $10 million, $200 million, $1 trillion. It all has the same impact on them because they're already dead. All right. So why am I wasting my time to try to get punitive damages? I know the court has that question. The reason is this. We have made offers of judgment in this case, and I don't want to get into the amounts.
The court can't.
Court can't consider the amounts of offers of judgment. But the rejection of the offers of judgment, we've cited case law in another motion that's related to this. Insurance companies liable for whatever the jury comes out of in this case. That's going to be a bad faith case at a subsequent point in time, but they've put themselves in this position. And so when we went over to bankruptcy court, we agreed that we would not look to the assets of Real Water. We're not going after whatever assets they got. I think they managed to collect a grand total of $35,000 selling everything. But we're not making a claim against them in bankruptcy. We've agreed to do that, and we're going to honor our agreement. We've agreed to go solely against the insurance companies. In this case, it's Four Liberty Mutual Companies. I can't remember their exact names. But so that's going to be the issue at a later date with another proceeding as to whether or not there's liability for the compensatory and the punitive in that. And like I've already said, there's 8th Circuit case law right on point. So for this reason, we don't think there's good cause for the amendment. We don't think they can be allowed to present an annihilation defense because they cannot. This is not a rare case where they will be annihilated. And I don't know what the reference was to the constitutional argument. The United States Supreme Court has set forth guidelines on punitive damages award. BMW versus Gore says 4, and State Farm versus Campbell says single digits. And the Nevada Supreme Court has come, I think they've approved 12.2 and 12.4 to 1 in 2 insurance cases. Judge Posner's a little bit above that, but those are constitutional limits. That's not what we're talking about here. We are talking about, to get to the constitutional limit, that's a motion filed with the court after the jury renders verdict. And I'm not arguing, I don't know where Mr. Odou got this, maybe he's being overly cautious. I'm not arguing that if they don't raise an annihilation defense, they can't raise their constitutional claims later. I'm not arguing that. I'm arguing that they can't raise the annihilation defense because there's not good cause, and they can't prove they're going to be annihilated. They annihilate themselves. When you shoot yourself in the head financially by filing bankruptcy, you can't come to the jury and pretend that any award they're going to give is going to annihilate you. So that whole prong of punitive damages is gone. Remember, punitive damages are rendered for 2 purposes. One is to punish, one is to deter misconduct in the future by others. Okay, and I think you've heard a couple times today that no one knows. No one knew about this hydrazine problem. It was, this message needs to get out there. So we think there's a strong deterrence reason for punitive damages in this case, and not a punishment reason. We're not saying they should be punished, but because we're not trying to punish them. Indeed, we can't punish them. We've already stipulated that we can't recover the punitive award against Real Water, just the insurance company. And there's no argument that Liberty Mutual can be annihilated because they have a net worth of $164 billion. No way the jury's going to give us $164 billion, right? Well, hopefully not. But in any event, Your Honor, those are the reasons we think this would be futile. And I would focus on the good cause, because you didn't hear one single word as to why this wasn't done earlier.
Thank you. Counsel, you get last word. Mr. Just got a quick question for you. This particular pleading uniquely did not have your name on it.
Yes, Your Honor, it must be an oversight.
You know what I'm referencing, right? I mean.
Yeah, the top, I wasn't able to, I'm having computer issues today, so I'm arguing from my notes rather than from the motion. But apparently I must have been omitted from this one. Hopefully I didn't get let go and I was notified.
No worries. I mean, you still all show as co-counsel. it was more of in light of some prior statements about different people, okay?
Yeah, no, we represent, to be clear, our co-counsel and our firm represent Real Water in all aspects. We defer to them as to Brody, just for the division of labor. Thank you for bringing that to our attention, and we'll make sure that we get that cured going forward.
I just wanted to make sure this is something I need to take into account. Feel free. Go ahead.
Thank you, Your Honor. It was very fascinating to hear the plaintiff argue that Real Water had shot itself in the head by declaring bankruptcy. Quite a visual for the court. I don't mean to dissertate the court on constitutional history or argument, but certainly many of the founding fathers' grievances in establishing this country was the ability to get a fresh start, not go to debtor's prison, and be able to declare bankruptcy. I don't think the founding fathers would say declaring bankruptcy is shooting themselves in the head. The reason why I raise that, Your Honor, is because we have raised this argument previously, and this is our good cause. Plaintiffs have argued in other matters, the BMW case and this constitutional protection to be able to declare bankruptcy is something that would bar us from making the argument if we don't raise it as an affirmative defense. So yes, this is a belt and suspenders. The good cause is plaintiff's argument. Now I hear them shifting their argument that in this case, they're not going to make that argument. They're not going to claim there's some type of constitutional waiver. But again, we believe belt and suspenders, this affirmative defense, should be pled. Also, I think it's necessary to correct the record in terms of the bankruptcy filed by Real Water. Originally, it was a reorganization bankruptcy. It got shifted to a liquidation. So again, Real Water did annihilate itself. Its debts annihilated it. And again, we don't believe that, and this is the subject of all the motions, we don't believe you can punish a bankrupt defendant with punitive damages. I think that is an interesting area of the law. I don't want to get ahead of ourselves, but no one has found any case law supporting that one way or the other, and so that's an argument the court's going to hear. But in terms of the constitutional issues, we believe we should be allowed to add this affirmative defense. It's not prejudicial. There is good cause because the argument has been made as to whether or not there's a constitutional waiver. We don't believe you can waive your constitutional rights. Again, not to lecture the court on interesting constitutional issues. Thank you, Your Honor.
Thank you. I do have one other quick question on substantive, more from a timing standpoint. I didn't see anywhere in the pleadings that the motion to amend the answer would have any impact on the current trial,
No.
any deadlines, anything. Can you just give a confirmation one way or another?
In Real Water's view, it has no impact at all. It's just an argument that if the jury, if the next motion in limine is denied, and if the jury is going to consider punitive damages, it's a further argument that we will be having at the court before phase 2.
Okay, the court is going to grant Real Water's motion to amend the answer to plaintiff's third amended complaint, document 543. Really, the court's analysis in this regard is, as been articulated and stated, focusing once again on the Hunwardsen case, while there's a different statement during oral argument the way it's been litigated in this case, realistically, the court does find that there's good cause based on what has been presented to this court in this case, and realistically that this affirmative defense has pretty much in part already been articulated, tried, and been brought forth as that it would be a part of the case, and so the court takes no ultimate position on how it can be used, but it can at least be amended into the answer. It is so ordered. Moving on to the next one, document 595, Real Water's motion eliminate. Now, just for clarity, that last one was Real Water's motion eliminate answer, and then there was a little misnumbering issue between a 15 and a 16, and that's not.
Yes, Your Honor, I apologize. That was a coordination issue. The next we have is document 595, which was misnumbered, but is Real Water motion eliminate number 16.
Okay. Just want to make
There
sure
we go.
you understand. In one pleading it said 15, in one pleading it said 16. So for clarity in the reply, it was clarified that it was 16, not 15.
Yes, 595.
Yeah. So the court's going to document 595, Real Water's motion in limine to exclude plaintiff's punitive damage claim against Real Water defendants. So now I get to hear the flip argument. Go ahead, please.
Hey, good morning, Your Honor. Mark Love on behalf of Real Water. As we've already heard, Real Water is dead. They went into Chapter 7 bankruptcy. They've been dissolved as an entity since 2021. They're not available for punitive damages. So then the next question is there insurance coverage available for punitive damages? There was an order providing relief from the bankruptcy stay, which states that Real Water is a nominal party. Plaintiffs can't obtain damages from them in any way, and then they can only pursue Real Water to the degree that there's insurance coverage providing coverage for the potential damages. Just quoting from the relief from stay order, it states, the claimants waive any claim they have in the bankruptcy court, and the insurers, all of their defenses are fully preserved. And plaintiffs can only pursue Real Water to the degree that there's insurance coverage available. Well, frankly, there's no insurance coverage for punitive damages. Generally speaking, in Nevada, it's not entirely disallowed, it's frowned upon in the state, but there are possible ways of doing that through a special insurance policy. But none of the insurance available to Real Water here provides coverage to punitive damages. And I'm sure Mr. Kemp's office has copies of the policies. If there was something in there indicating that there was coverage for punitive damages, I'm sure he would have provided that to the court with his opposition. So ultimately what we come down to then is we have an entity that's dead, that's not available for punitive damages. We have no insurance coverage for punitive damages. And so if we spend, 8, 9, 10 court days going over a punitive damages phase against Real Water, there'll be a massive waste of the jury's time and the court's time trying to put up a punitive damages award against a company that doesn't exist and that won't be collectible. Now, plaintiffs have indicated that there's two purposes for punitive damages, and we started the case Lombardi in our papers under Nevada public policy. One purpose is to punish a bad actor here that a bad actor's dead, no point in punishing him. And the other purpose would be to deter others. But frankly, under NRS 48.035, I think, again, wasting a week of court time to simply amount to putting out what would be like an advisory opinion almost regarding entities that aren't parties to punish an entity that doesn't exist anymore would just be, a giant waste of court time. If we did have a punitive phase here, then, we'd be putting on evidence of Real Water's current status. We'd have to tell the jury that they're bankrupt. Plaintiff has an expert, Mark Rich, who did a report analyzing the various defendants and their current solvency and status to pay a punitive damages award. Makes no mention of Real Water in his report whatsoever, for obvious reasons. They're bankrupt. Potentially we may even have to introduce evidence from the Gallagher $200 million punitive damages award, potentially. There's a lot of things that we could get into if we end up having punitive damages in play here for Real Water. All basically for a show where it's not going to be collectible. Plaintiffs in their opposition, they throw a lot of dust up in the air and they talk about all these coverage cases, about various situations where insurance companies have acted badly towards their insureds. And the result was trials where you have verdicts that were in excess of what the coverage was available. But in every one of those cases, the insured was an existing entity that suffered a real harm. And here we have a company that's, in essence, immune from any possible damages in this case, so there wouldn't be any real harm. So all those insurance coverage cases just aren't applicable here in this situation. Ultimately, Your Honor, I guess what this all boils down to is this. Real Water is dead. They don't exist. They're not available for punitive damages. There's no reason to do some sort of punishment for an entity that's, a dead horse. There's not going to be any insurance coverage available to cover punitive damages. And so having a punitive phase here would just result in days and days of unnecessary court time that would be wasteful to the jury. In fact, with Real Water stipulating to liability and to causation in all but one of the plaintiffs, this could be a much shorter trial without the punitive phase. We just go straight to, causation and damages.
Court does have a question.
Please.
I didn't see, are you saying that there's any case law that says collectability versus merit should be the standard on a summary judgment?
On a summary judgment?
You're treating it as a motion limine, but basically it's a summary judgment, it's a partial summary judgment, right? Punitive damages, it's usually treated as a partial summary judgment. It's not usually a motion in limine. So whether you do it under the standards of 56 or do it under the standards of how you actually did it,
right.
It realistically, but I didn't see any case law that said, well, first off, don't worry about the court's time, we have you blocked out, okay? Don't worry about that. My staff and team and myself are here for you all, don't worry about that part. But then the second part is, I didn't see any case law that said collectability should be the basis to grant, like I said, whether you call it a motion for partial summary judgment or you call it, here you all called it as a motion in limine, right? The court has to look at the substance, not the titles. How that would mean that you should exclude punitive damages.
Well, Your Honor, I think we phrase our motion as a motion in limine. You're right, to some degree it feels a little bit like a summary adjudication or partial summary judgment.
Actually, under Nevada case law, yes,
I'm
but
sorry,
okay,
right.
but it's okay. Whichever label you want to put on it. So the court's analyzing for both standards, giving you the benefit of the doubt. But I didn't see any case law on either standard when it says the argument really is collectability contentions versus the merits of whether or not punitive damages should or should not go forward based on the evidence.
And Your Honor, I think we didn't find any case law one way or the other on that, and hence we focused on 48.035. So the focus of our motion was really, again, putting on days and days of evidence where it's not going to be collectible. It's just, hate to have jurors in the box for 6 weeks instead of 4 weeks. to come out with something that may be meritorious but not collectible.
I appreciate it. Thank you very much for your argument.
Thank you.
For plaintiffs, would you like to respond?
Sure, just briefly. First of all, this horror story being presented that it'll take 10 more court days, wasting a week, 6 more weeks instead of 4 weeks. Your Honor, the punitive phase in the Gallagher case took 2 hours. 2 hours. That's how long it took. And I'm including the jury deliberations. It took 2 hours. So the punitive phase in this case, we have one witness, Mr. Rich. I put forth what he's going to testify to with regards to deterrence. They don't have a witness. They haven't designated any witnesses, any extra witnesses. So I don't know where he's getting this long time period. But even if it was a long time period, that doesn't mitigate the right to relief if you're entitled to it. With regards to collectability, I think the court hit the nail on the head. It doesn't make a difference. Basically, he's arguing if you're a poor person, a hobo or something, that you can do anything you want to do and you can't have punitives rendered against you because there's no collectability. That's not the law, Your Honor. And the real thing that bothers me about this is he comes in and he says, well, Judge, there's no insurance coverage for punitive damages, but there's a debt relief action going on right now over there in federal court where, and we put forth the claim for relief, the insurance company is suing Real Water for a declaration saying that that's a disputed issue, that Real Water takes the position that there's punitive coverage under the policy. That's what the debt relief action says, and that's what we've quoted in there. So that's completely contrary to what he's represented to the court. But what we have here is really a motion by an insurance company, because Real Water doesn't care. We've already stipulated that we're not going to go try to get any Real Water assets. So it doesn't matter if the punitive award is $100,000, $10 million, $200 billion, whatever it is, because we've agreed not to try to collect it from Real Water, just to go against the insurance company. So what they're really trying to do is they're trying to get rid of this damages component in the bad faith action. That's what they're trying to do. They don't want us to sue Liberty Mutual and say, hey, you rejected the offer of judgment, so you're liable for both the excess compensatory and the punitive award, which is what the Eighth Circuit case says we're entitled to. But that should be a motion filed by the insurance company, not by Real Water, and it should be filed in the coverage case, not here, Your Honor. So what they're really trying to do is they're trying to eliminate the punitive damages award at the outset, so the insurance company doesn't have to fight that issue, and that's just not appropriate. With regards to deterrence, I mean, punitives are two purposes. They're talking about punishment, we're talking about deterrence. What is an appropriate reward to deter others from having this misconduct? I'm going to argue the jury's got to be high, because here we have an unknown factor, hydrazine, that could have been tested with a $200 test if they'd done it at the outset of the history of the product, or at any time during the history of the product. So we're going to argue that this message needs to get out there. And collectability, that's an issue for another day in another court in another case against the insurance company.
You get last word, Counsel. Go ahead.
Thank you. Now, I'd just like to point out, as Mr. Kemp mentioned, in Gallagher, their net worth testimony for punitive purposes was just one witness, Mr. Rich. He'll be the same witness in this case. He provided a report. He didn't mention Real Water in his report. And so I think, punitive damages shouldn't be, even talked about for Real Water, because their one witness on the subject didn't even mention us in his report. Further, under Nevada law, punitives are based on the net worth of the entity. And so we get to, this is the point of Mr. Rich as a witness, is to talk about what the net worth of the various entities are. And here we have an entity that doesn't exist. Again, I think collectability is an important factor, because if you're going to put on a net worth version of or portion of the trial, and we find out that the entity at issue is bankrupt and is not collectible against, again, it's just sort of a waste of the court's time, and not only not collectible, but then meritless at that point under Nevada law.
appreciate it, thanks very much. The court's ruling with regards to document 595, Real Water's motion limited to exclude plaintiff's punitive damages claim against Real Water defendants, regardless of whether the court takes it on what a motion for partial summary standard, since it's really asking for a preclusion of the whole damages component, or the court takes it as it was phrased under a motion limiting standard, it would need to be denied on both standards. Realistically, as articulated in the pleadings and a re-articulated oral argument by counsel for plaintiffs, punitive damages has a couple of different purposes, including deterrence. So realistically, when you're looking at the deterrence factor, that's going to be a fact-based determination by the jury to determine whether there needs to be a second phase that goes into punitive damages, and including the two purposes, including deterrence and punishment. The court really does not need to go to anything that may be happening in other courts or may be happening in the future, because that's not before the court. The court has to look at actually how this motion limiting was provided to the court, and it doesn't have any case law realistically supporting the concept that there would be a basis to exclude punitive damages claim. The additional statement about really court time, the court has, you all allocate the time for potentially punitive damages phase, whether it happens or not is really up to the jury. Court's time is the court's time. The court's going to be here. He's allocated when there's time. If it's merited by the evidence, then you end up with a phase on punitive damages for the jury to determine whether or not, for either the purposes for punitive damages, whether they are or not merited under the applicable evidentiary standard. So the court does not find that the motion has met its required proof under either a Rule 56 standard or the motion limiting standard that was correct, but that it was actually set forth, so the court does need to deny it. It is so ordered. Seems to me, ladies and gentlemen, given the time, this is a perfect time to take the lunch break. Do you want to come back at 1:10?
Sounds good.
Makes sense? 1:10? Okay.
Thank you.
And we'll then continue with the next one. Thank you so very much.
Can we leave our subject?
You can leave your stuff as long as you don't need it during lunch break, because my team needs their break. I understand for a while. We appreciate it. Thanks so much. Okay, we're back on the record in case 831543. Counsel for Real Water, I think you said you had a housekeeping matter. Go ahead, please.
I do, Your Honor. We can either take it up now or later. I just wanted to make sure that the parties are meeting the court's expectations as far as the designations of video depositions to be played. I've reviewed the court's handout from the court website, compared it with the dates that we've set, and if the court doesn't mind, I just would like to go over those dates so that we're not missing any of those deadlines that the court expects us to meet.
Since your deadlines are the deadlines, I'd have to double check. Do you really, I would have to get some background.
I can explain, I think, and
What's
maybe
your
the
question?
court will see where I'm coming from. Currently, the final pretrial conference calendar call, if you will, has been moved to January 3rd. 2 weeks before that date, in reading the court's order from the website, would be the due date for the designations. That would be currently, I think it's December 20th or so. Then 1 day later, there would be counter designations. Then the court would have a hearing on December 27th, With the holiday in between, I want to make sure that's enough time for us to get the counter designations, meet and confer, resolve any objections, and then be here on the 27th for a hearing.
Okay. When I did move the calendar call date, remember I said I wasn't intending to move any other dates. I was just giving you that one date. So are you triggering it from the 3rd or the 2nd? Your timing.
Then the deadlines would just move back 1 day, but it's still the weekend of Christmas. I wanted to make sure that we get the court any issues that we cannot resolve in time. So if we can keep the current dates, we would have our designations done on December 19th. December 20th would be the deadline to do counter designations. We would meet, confer, and presumably get an objection to the court that for issues that can't be resolved by either December 22nd or, no, it'd have to be December 22nd because the next 2 days are theme park.
Realistically, these are like last and final deadline dates. Most people get it to the court a lot earlier. So these are the most generous ones. So yes, I mean, that's what we're going to have to do to get you all taken care of with the dates you all selected for trial.
Yeah, Judge, I think we're filing ours tomorrow.
I mean, the rule on final pretrial disclosures provides that deposition designations are included, so that's the deadline we've been working off of.
Just to be clear, what we have tried to do, and remember, no one size fits all, as it even says in the court's rules, right? It talks about smaller cases and larger cases, and then, right, unless otherwise ordered by the court, et cetera, because as you know, for example, in construction defect cases, deadlines are a lot more in advance than anything under the rules. For many of the larger cases, that's the case. You all have a unique case in that you asked me not to do stuff while you could take care of Gallagher, for those of you who are involved in Gallagher. So that just meant that things were
Compressed.
where they are. Thank you, yes, to where they are now. So realistically, I need the information in order to make the rulings. You all need the rulings in order to have things prepared for depositions. So unless if you want to get them to me earlier and that's fine by the court, but I can't have them any later than the 22nd because realistically, on the 22nd, what that means is
And that was
pretty much any other holiday or weekend I'm working. So, that's the issue. I thought we had these scheduled, but I get everything no later than the 21st, but I thought we had more days. But once again, I'm prepped for all these, right? You know what I mean? To go look at dates and figure out dates and do that would take a few moments.
I agree, Your Honor, and perhaps, we could take it up after the afternoon break, but I hear counsel for plaintiffs saying they believe they're due a different date. We believe that would conflict with the court's handout, and so perhaps the parties should meet and confer, decide when they're really due, just so that we're not missing a date and leaving the court without enough time.
With regards to our handout, like I said, it usually anticipates like a single designation, right? For example,
Yes.
once again, not to quote other cases, but yes, to quote other cases. In the opioid case, there was somewhere between 89 and 119. Okay, you can appreciate with those video depositions and lieu of live testimony, those definitely weren't a couple of weeks before trial from a pure timing standpoint. But also has to take into account if you all have special masters and the scope of the special master's duty in a particular case that might have earlier deadlines. These are the very, very last and final deadlines to try and take this into accommodation. With regards to anything, yes, the rules are going to go over ours. Ours are only to the extent that we can additionally add things to try and accommodate people with regards to things that we can do within the court's discretion. So honestly, you all would have to walk through and let the court take a moment to actually look at what each party is referencing and what you're requesting. The short answer I need to give you right now is, yes, I need them in order, appropriate time for the court to review it in order to do it on the 27th, if that's where we need it, in order to get you your video depths that you want, particularly if people are wanting anything for potential opening statements, right? So.
Your Honor, perhaps I could suggest if the court wants to provide us with the deadline to provide the deposition designations and counter designations prior to the hearing, I will meet and confer with Mr. Odou and counsel for Terrible Herbst, and we'll come up with a schedule so we meet that deadline.
Well, as you know, it wasn't even until this morning that I even knew you were doing deposition and lieu of live testimony. So realistically, I can't schedule things when I don't know that they exist. And so I'll take a look at it. Do you want me to take the time right now, or do you want to get to your next
No,
motion?
I accept Mr. Pepperman's representation. It would be fine for us to meet. That's the reason why I brought it up as a housekeeping matter. Certainly Terrible's, Real Water, and plaintiffs can meet and come up with a schedule that works for this court that's in compliance with this court's rules.
I think the court rules in any way conflict with any of the other rules, and there's going to potentially be a change in the audio visuals. Ours will change as well. It hasn't made that change yet. Yes, I mean, it seems to me you all want me to get to the actual motions and then
Yes.
give a break so that I can at least have some idea of what you're referring to with regards to what line of now these numbers, because remember I've got somewhere 12 to 15 potentially, 3 to 5, and somewhere less than the 30 of the witnesses, potentially half of them, but not even sure of the overlap. All of those you all need to give me an actual number, right? So that, because you all ballparked it no longer than an hour to 2 hours, right, for regards to hearing. So I gave you a hearing on the 27th. If that also has more change, then I need to know. If that's where you're going, I can get it If there's only gonna be a few things, I can do it on the 27th, I can get things no later than basically on the 22nd, because I can review everything. If you all have changed your game plans and you're going to expand things, then obviously this court's gonna need to have more time to review it. If we're just talking about some short designations. Like I said, we try to be as generous as possible, but once again, it depends on how many, and whether you're talking about just the same, as you said, you all got your specific number of categories, right? Did you reach out to people over here in court? Okay. So.
That's helpful, Your Honor, I appreciate that. I think we can meet and confer and resolve this.
Yeah.
Thank you, Your Honor.
Thank you, sir. Okay, so let's get to the next one. The next one is document 676, ETT motion limiting number 22, to exclude Eric Pepperman's testimony. Plan 13, document 833 is the opposition there too. The reply is document 953.
Judge, I think that's moot because
My next sentence would be, I'm going to ask everyone if I still heard this in light of yesterday's ruling with regards to the DAB theory, but once again.
no, we're not gonna call Mr. Cohen.
Moot for a different reason, okay.
Well, we don't need to call him now.
Okay, so that's being withdrawn?
Jan Tomasic for Terrible Herbst. As long as the stipulation comports with plaintiff's opposition. On page 3.
Wait a second. Hold on a second, counsel. If they want to withdraw a motion, you're saying they can't withdraw a
Well,
motion?
it's our motion, and so
I'm sorry, it's AT&T's motion on the
Right.
22, my apologies, go ahead, please.
and so as long as the stipulation is that Eric Cohen is not being called as a witness at trial, we can render this one moot and withdraw the motion.
That's the intent here.
Okay, just want to make the record clear.
Okay, so is that a stipulation under 87.50 or?
Yes, Your Honor.
Yes.
Okay, so then, Courtney Nuttall, motion limiting number 22, you're treating that as withdrawn or pursuant to stipulation of the parties, how are you treating that one?
I would treat it as, stipulation.
Counsel, that means
I'm
you're.
fine with that, Your Honor.
Okay. So per stipulation of the parties, Courtney Nuttall on document 676, thank you so very much. Okay, moving on to document 610. Real Waters, motion limiting number 2, to approve the use of MMRW to argue prior peaks are related to real water, document 856, plaintiff's opposition thereto. And join your document 734, and reply document 905. Real Water, this is yours. Go ahead, please.
Thank you.
I just need to change. Okay.
Your Honor, Joul Odou on behalf of Real Water, I'll be very brief. This is a motion to exclude argument that the peaks in the MMR are specific plaintiffs that are not identified in the MMR. The issue that we have with this report is generated by making queries under health databases as to certain symptoms that were reported at various hospitals for the potential illnesses of people. But to tie it to a specific person, either that person should be named in the report, and certainly there's probably one exception where we can tell who that person is because we've had one death, and that was in the prior case that was taken to trial, so we know who that person was that was in the report. However, plaintiffs want to go prior to 2020 and argue that specific peaks and specific data outside of this report are peaks and valleys caused by injuries to specific plaintiffs. To do so, they say, well, they can make reasonable inferences from their expert, Dr. Hudson, who's a medical doctor. Well, they can take reasonable inferences, but Dr. Hudson didn't opine as an example that the 2019 peak is Myles and Hunwardsen. It's not in his report. And so to the extent that the plaintiffs want to argue outside of the four corners of this report, they only could do so if there was an expert who said this data or that data is related to plaintiff Hunwardsen or Sosa or whatever plaintiff they want to make. This becomes a very prejudicial argument because the argument becomes, look at all these peaks in the MMR report prior to 2020. Those are all people injured by real water, and therefore real water should have been on notice, therefore real water is responsible for punitive damages. That is a highly prejudicial argument, Your Honor, and it's not a reasonable inference, it's speculation. All we know from the peaks in this report is that it met a specific query of the healthcare professionals who were compiling this report. That query included, I don't know, probably about 15 different potential diagnoses. And yes, the report says it's related to alkaline water. It doesn't say this person or that person was poisoned by real water. And that's the argument that the plaintiffs are making. And that argument, we believe, is speculation and should be excluded. And it's prejudicial speculation.
Thank you. Counsel for the plaintiff, would you like to respond?
Briefly,
Excuse me, I'm sorry. You know, I had an AT&T joiner, a non-substantive joiner. Did you wish to be heard?
No, Your Honor, nothing further.
Okay, sorry. Then go ahead, counsel.
oh, no worries. Thank you, Your Honor. Your Honor, first, under NRS 52.085, the document is self-authenticating. It's a public document maintained by the CDC. I don't believe Mr. Odou raised an issue regarding the authenticity of the document and whether or not it's used by experts, because it is used by experts and it is a document under the statute that should be allowed. I believe that Mr. Odou's concern is how we use this document. And certainly we've cited the case law, which allows attorneys, both plaintiffs and defendants counsel, to discuss the impact of those that information out of the MMWR in front of the jury. And the spikes happen to correlate to the outbreaks. And there have been outbreaks in 18, 19, 20. And what the defendants hate to admit or concede is that it's not coincidental that those spikes and peaks happen to coincide with several of our plaintiffs, one being Hunwardsen in this case. We also had Keith Haley, as Mr. Kemp spoke of earlier, who was in 2019, as well as the baby, Orion Gallagher, also identified in one of the MMWR peaks. So, Your Honor, we have a right, based on the case law, to actually argue the impact and why the MMWR report coincides and correlates to the spikes and peaks in the outbreaks from real water consumption. The other thing, Your Honor, the MMWR report is a culmination of the requests from public agencies and authorities asking for information regarding people who, in Clark County, were affected by potentially the consumption of real water. So, Your Honor, I don't believe that there's no case law cited by the defense that supports their position. The statute supports the use and the admissibility of MMWR report, and I believe for that reason the motion should be denied.
Court's got a good question. With regards to who is going to be the witness that would be discussing the report and the quote peak prior to 2020, or witnesses?
Well, Your Honor, I believe Dr. Hudson could speak to it.
Is it disclosed as part of Dr. Hudson's? Because you understand my next question on each of these is going to be, if you're saying it's an expert, right, then was it a disclosed opinion in the report? If it's a lay witness, I have to ask
Right.
how the lay witness can do it when it's a
Well,
report.
in addition to Dr. Hudson, Your Honor, and I can't recall specifically, I have his report ready. I don't recall it being necessarily referenced in the actual report, but it could be a part of his job file. So that's one reason I'm hesitating on responding to that. But certainly also the 30B6 for the Southern Nevada Health District could comment on it as well. And so there are many ways we could get this document in, Your Honor. We used it in varying ways in the last trial. And so certainly it's my belief, Your Honor, just based on the statute, it comes in, number one. And Mr. Odou did not make an argument based upon NRS 52.085, subsection 2. And again, he argued the potential inferences that be used or argued by plaintiff's counsel, but I don't believe it prevents the admissibility of the document and the use of the document.
Right. And that's where I'm trying to get clarity, because the way that the motion reads, right, including the conclusion.
Right.
They're very nice specific on what it is. It says, at the above stated, real water process, the court entered an order granting a motion number 2, that the order further, I think there may be a word missing, the order further state or whatever, but it says the order further 1. Parties may not use the MMWR to argue that prior peaks are related to real water. That's where I've seen the very narrow aspect of this motion, not the preclusion of the document itself.
And
So that's why I was asking the question about who would be testifying to link quote, prior peaks are related to real water.
well, let's first consider the genesis of the document.
Sure.
And this document was created as a result of the 2020 outbreak, and they went back and took a historical look between 2016 and 2020 to consider what's been going on here in Clark County. And they asked through a database sent to all of the hospitals within the area to figure out what was happening and whether or not there were any other acute liver failures with an unknown etiology, which was also non-viral. And this was the information that was revealed through that query, John. And that showed the peaks. And that information, again, because it's something that's the MMWR report is maintained by the CDC, who also participated in this investigation along with the Southern Nevada Health District. Your Honor, I believe that 30B6 could, from the Southern Nevada Health District, yeah, bless you. Bless you. They always come in pairs, I've found, sneezes. Sorry, for some
Yeah,
reason.
when I tried to sneeze yesterday, you all gave me grief.
No, I was the first one to say, bless
It's
you.
like, I only gave one sneeze.
He didn't hear it.
Yeah.
I heard it, I said, bless you.
No,
Your Honor.
okay. So you
But-
understand what the court's question is? The court's
Certainly.
question is there a designated witness who is going to set forth that the prior peaks are related to real water versus as was articulated in the papers that there is, quote, I'm phrased a variety of different ways. Some people say, unknown, right, not clear. So that's why the court's asking the question. I mean, has there been somebody deposed, somebody who's actually going to tie in that report to say those peaks are real water peaks?
Well, that was the only product at issue, Your Honor. It was alkaline water that's mentioned there, but I believe we pulled the MMWR report up. I can't remember what exhibit number that is.
No, I think you have it. There you go.
There we have it. And may I approach
Yeah,
here,
of
Your
course.
Honor? Thanks.
Yeah.
So we deposed the 30B6
Can you hear
is,
okay? Just let me just make sure microphone wise. Can you hear okay?
can you?
Yeah.
Okay. So Your Honor, the second name here was the 30B6 that was deposed in this case.
Sure.
And you see it's confined to Clark County. If you make it a little smaller so we can see more text, Shane. And real water, right up top, second column, Your Honor, probable cause criteria, real water offered a variety of products including 5-gallon home delivery available regionally in smaller bottles available nationwide in grocery stores through online vendors. So this suggestion that this was some canvassing of all alkaline water without any definitive relationship to real water is just not true. And so I wanted the court to see this is a more fine-tuned article. And it even mentions in the first paragraph the Southern Nevada Health District, the CDC. And so I don't believe that there should be any question that the Southern Nevada Health District 30B6 person would be able to provide testimony on this article, Your Honor.
I appreciate it. Thanks very much.
Thank you. Hopefully that was helpful, Your Honor.
Yeah, like I said, in light of, A, I've got to get a clarification on their scope, and B, I've got to get a clarification in light of.
Can we leave that up?
Sure.
Mr. Guthrie, if you don't mind, could you scroll down to the footnote below the graph? I think it's on the next page, I think. And can you blow up that footnote? Your Honor, I'm not going to attempt to say all the medical terms in the footnote that's denoted with the squiggle, beginning with query terms were as follows. There are 15 categories in there of the query terms that were used to create this graph. So in other words, this graph is a compilation of somebody running a database search for things like diagnosis. I got to put my other glasses. This is a reading test here, an eye chart.
I think it could be made up bigger there.
Diagnosis of code of toxic liver disease or hepatic failure not elsewhere classified, and no discharge diagnosis of chronic hepatic failure, acetaminophen poisoning or adverse effect, autoimmune hepatitis, primary biliary cirrhosis, and so forth. So they excluded certain terms, ran a query, and got people basically with liver failure. And we're not objecting to, at this point, to the admissibility of this, but you can't take those search terms, even if you're excluding those search terms, and say, okay, everybody else that doesn't fall under one of these queries was poisoned by real water. That's what the plaintiffs are trying to do. There is no expert. Dr. Hudson doesn't say that. We said that in a reply, that Dr. Hudson doesn't say that. We invited them to show us where Dr. Hudson says that. Dr. Zhang, who's the author of this report, she doesn't know the plaintiffs, so she can't tie the foundation between plaintiff whatever, Hunwardsen, and the 2019 peak, or plaintiff Sosa, or plaintiff Brody, or any plaintiff. So the problem becomes that you have this anonymous data that is used to compile this report, and as I alluded to in my first argument, we know the death case. That's not in this case, and it was never an issue, because we know Kathleen Ryerson died. And so we know that that's the death case that's talked about in this report. What we don't know is if any of the other plaintiffs are talked about in this report, if they're not named. Mr. Parker mentioned Mr. Haley and Orion Gallagher. We don't know that Mr. Haley or Baby Gallagher is involved in one of these peaks. We can assume, we can speculate that they are, but we don't know that, and there is no expert or witness that can lay the foundation for that. So the argument that they want to make, we're not seeking to exclude the report, we want to exclude improper speculative argument that these peaks are specific plaintiffs or caused by poisoning of real water of specific people.
Can you scroll up for a quick second? Let me look at the chart. Would you mind?
That's right.
Shane, would you? Mr. Godsby, would you mind moving it up there? Thanks much. Okay, so let's focus on the peaks we're talking about, just so I can see the visual when I'm hearing yours, and I'm going to give opposing counsel a moment to respond, then you're going to get last word, okay?
Yeah.
Just so we're clear on what this is. Go ahead, please.
All right, Your Honor, if we actually, so we see the peaks and the valleys, and we see the years, 2016, 17, 18, 19, 20. If we scroll down now and we look at the footnotes beneath the chart, the first thing it says is 18 probable cases were identified in Nevada and 3 in California. We could stop right there. Through discovery, through the efforts of the parties, we have a fairly good idea of who some of those 18 people are and some of the people in California. We don't know for sure, but we have circumstantial evidence. That's not what we're arguing here. We're saying you can't take, for the plaintiffs in this case, these plaintiffs, which one is a probable case, unless it is mentioned in the 4 corners. We go on. Probable cases must meet the following criteria, and it goes on and on. The plaintiffs made an issue of this that, okay, if it doesn't meet the criteria, it doesn't fall in an outbreak case, that's the subject of another motion, but they can't have it both ways. They want to say that there are these outbreaks and our plaintiffs are in these outbreaks, and then in this motion they'll say, well, our plaintiffs are the specific peaks or in these specific peaks. We don't know that.
So let's go back to Zhang's deposition, which wasn't fully, I mean, there are some
She's
assertions of what she did and did not say, but there's not some of the specific testimony. Are you contending she was able to say who's represented in these groups?
No, she was unable, she didn't know any of the plaintiffs, she didn't know who was a plaintiff. She's an outside physician who was a co-author of this report.
Okay.
And so if we said, Dr. Zhang, where does Orion Gallagher fall in this? It would be, who's Orion Gallagher? Where is, Myles Hunwardsen? That wasn't the exact question asked, But that's the gist of it, because at one point she was asked about the plaintiffs in this case, and there was she asked for clarification, who are the plaintiffs in this case? And I don't recall if she was deposed in Wren, Gallagher, or Hunwardsen, it doesn't matter. That's a tangential issue. What matters, though, is when she was deposed, and if she is brought to trial, she will not be able to say, this peak correlates to when, or this peak correlates, to Myles Hunwardsen. This peak correlates to Plaintiff Sosa, or this peak correlates to any plaintiff other than, like I said, the infants, they're a little bit different. They're not in this case. And the death, that's a little bit different. That's not in this case.
Okay, but your motion limiting also seeks to have a determination that they're not attributable to real water. And both in the written opposition as well as the oral argument of Mr. Parker, he asserts that the scope of this actual report, and will be able to come through either, right, a
So if we-
CDC person, that they all are real water. Well, you might not be able to identify, he didn't say this next sentence, well, you may not be able to identify a Hunwardsen, it's a real water.
And no, it's not, and let me explain why. Because if we scroll up above the figure, it says probable cases of acute non-viral hepatitis linked to alkaline bottled water among the residents of Nevada, California, so forth and so forth. So again,
So what
Alkaline
other alkaline
water.
water would have been the
We
subject of
don't
this
know.
report?
We don't know if other alkaline water caused people, and I'll give you an example why this matters. We have one of the witnesses the plaintiffs want to offer. They've referenced him here today. He's a plaintiff in another case. They said his wife made this complaint to Real Water that her husband,
Email in the hospital.
was hospitalized because of Real Water. Those were the words they said. Those are not the words that the wife used in her email to Real Water. The words that the wife used in the email to Real Water is, the doctor told him not to drink alkaline water. Huge difference, huge difference. So my point is, when this chart says alkaline water, there are people that can overhydrate with just normal water. There are people that can overhydrate and get water poisoning from normal water. There are people who can have a bad reaction to alkalized water. And we don't know that each of these peaks is because of real water. We know that these peaks and these queries are responsive to these search terms that were run here. Yes, they want Dr. Zhang to jump to the conclusion that this is all related to real water, but that was not the focus of her investigation. The focus of her investigation was to determine what is the etiology or cause of these hospitalizations. I understand they can make reasonable inferences, but they can't then jump to the conclusion that all of these peaks are from real water. So it's kind of two issues, and I get what the court is saying. The court is saying, can the court split the baby maybe and say, okay, this is where I'm going to draw the line. You can't say that this peak is Myles Hunwardsen, but I'm going to allow you to argue that this document is related to real water and these peaks are real water. I get that the court's saying, could I draw the line there? And what we're saying is, no, the court shouldn't, because there's no competent evidence to tie it all up in a bow.
What I wanted to look at the excerpt from Zhang's deposition realistically to see the question she was asked and the answer she gave. Because the focus more so of plaintiffs is that the only alkaline water that was an issue for purposes of the report was real water, alkaline water.
And that's
Now,
what we
she
disagree.
would know that one way or another, right? Because they would know.
And there's no way to know. All we know is when the search terms were put in, we can see what the search terms were, we can see what was excluded. What we don't know is the tie between the symptoms and a specific patient and the consumption of real water. In other words, when somebody goes, the problem we had in this case was when somebody went to the hospital, they were sick. The doctors are going to treat them. The doctors don't know what made them sick, right? They're doing a diagnosis, they're doing their best to understand, why do I have, in the case of Myles Hunwardsen, a 29-year-old person in the emergency room with liver failure. They're going through all of these things trying to figure out what caused it. The evidence is undisputed in this case. At the time of Myles Hunwardsen's liver transplant, no one knew that he was injured by real water. That came later. When this report was written, no one knew. All they're saying is there appears to be a correlation between the consumption of alkalized water and these injuries. We ran these search terms. This is these are the incidences. We've graphed it out. And here are times when people were complaining of injury unrelated to things like drug-induced liver injury from Tylenol or some other source. So we're going to graph it out. Now they want to take the leap and go, okay, well, if they weren't injured by Tylenol, they were injured by real water. And that's too far. That's a leap too far.
Okay, I'm going to let them have a moment or two to respond, since I asked you some questions, then you'll get final word, counsel. Councilor Plaintiffs, you can appreciate part of the challenge the court's going to have is you all were doing joint opposition, so it's somewhat unclear which portion of said pleading the court is supposed to be looking at for purposes of this motion versus the other motion, because I'm looking for Zhang's testimony. Go ahead.
No,
You have a chance to respond. Can you establish through a witness that it is real water versus alkaline water as is stated on the actual document?
Yes, so Your Honor, let's start there. I wanted to hit some other high points, but I want to address the court's question first.
Sure.
So we go to the second paragraph of the MMWR report. It says here, a probable case of liver illness associated with real water consumption included the following criteria. So the defendants have paraded this criteria before the court trying to establish this 2020 being the benchmark, August 1, 2020. This report deals specifically with real water. Now, what Mr. Odou has tried to persuade the court by showing the footnote was possible etiologies that were removed or considered. Mm-hmm. Nothing unlike a differential diagnosis where you figure out what could but did not cause the illness or the symptomology. That's where we are here. But this is a real water generated report because it's in response to real water consumption, which is described in the first paragraph. And that's why, Your Honor, I believe that the 30B6 witness for the Southern Nevada Health District would be able to discuss this report. Not to mention, I don't believe I heard, Your Honor, Mr. Joul say that under NRS 52 that this should not come in. I don't believe he approached that.
No, it seems, I mean, from what I'm understanding, with the clarifications of oral argument,
Sure.
is that the issue is that there can't be inferences or conclusions drawn that are not stated in the actual report. Is that correct, Mr. Odou?
Yes, Your Honor.
Well then, Your Honor, and this is the problem with
Because there wasn't somebody who could tie in to say, look, this is what we, if Dr. Zhang said, well, even though it says alkaline water, what we meant was real water, and I'm one of the authors of the report, so I know that, boom, that would be a different situation. Or if it said in the chart, look, we tested 3 different types of we had 3 different types of alkaline water. We had 2 different types, we only had 1 type, right? Different scenarios. I'm understanding the inferences and the phrases inferences, assumptions, or conclusions, they're not specifically set forth in the report as for what's being sought to be precluded. Is that correct?
Yes, Your Honor.
Okay.
And Your Honor, I appreciate that. Number one, which this is not a criticism and shouldn't be taken as such. If you're planning on bringing this kind of motion in limine, then you ask the questions of 30B6 at that time so you can actually support this position. That wasn't done, number one. Number two, since she is named as an author of the report, certainly those questions could have been asked, which could have potentially prevented this motion from going forward or be placed in a different form. But what Mr. Odou has done is putting the cart ahead of the horse. He's suggesting we shouldn't be able to ask those questions and get responses to them because perhaps someone on the defense side failed to ask those questions in an attempt to preclude such testimony. So, Your Honor, we believe that the 30B6 for the Southern Nevada Health District could answer those questions and bring further illumination of this report in terms of what else is there and what went behind the generation of this report. The other thing I would suggest, Your Honor, some of Mr. Odou's points are more raised to weight versus admissibility. I mean, the document is admissible under NRS 50, but additionally, the 30B6 witnesses' ability to talk about this document shouldn't be curtailed at this point because they never asked any questions that would preclude it. If for some reason they'd asked a question of the 30B6 witness, is there any information not contained in this report that you can't provide at the time of trial? That would be we'd be in a different position here. But that's not where we are. I think what Mr. Odou is concerned about is, could you put the chart back up for me one more time, Shane? And I think this is what the court was asking. With the exception of Ms. Ryerson, Mr. Odou is saying not one peak there can we associate with a specific plaintiff, Your Honor. I think that's what he's saying. If I'm mistaken, I'm sure he'll rebut, correct me. But he's, for example, suggesting that at the bottom here of 2018, we can't say that's Mr. Haley or Mr. Hunwardsen. We know it wouldn't be Hunwardsen because he's in 19, but I'm just using that as an example.
Sure.
But what we can say in 2019 is you see the peaks coming up. We know that 3 of the plaintiffs, Haley, Orion Gallagher, and Hunwardsen, are within this 2019 period. We also know in 2018, we had Belsky from the Gallagher case. So there is apparently a correlation between the outbreaks that we've dealt with, 2 and 3, and we use the definition in our response, Your Honor, you saw that.
Right.
The definition of outbreak being more than 2. And we've used that to show that there is a correlation between these peaks and the plaintiffs we have in these cases. And so can we say that one peak represents a person in terms of where on the peak? What we can say is there's several plaintiffs that have fallen within these peaks. Certainly 2020, the latter part is what started the investigation with the 5 children. But we have 18s, we have 19s, and Mr. Kemp, and I bothered him during lunch about this, stole a lot of my thunder on this motion. We also had in 2013 and 14 complaints of Terrible Herbst that predate this, that not on the chart, but we have also other customer complaints in the chart that Mr. Kemp gave you that also seem to correlate with these peaks. So we have customer complaints, we have plaintiff complaints, we have a plaintiff in this case. So, Your Honor, there is a correlation. Can we say exactly on each peak where each plaintiff falls? No, but we can say that multiple plaintiffs fall within certain peaks of this report.
I appreciate it, but
I didn't know if you had any more
no,
questions.
I did not. Thank you so much.
Thank you, Your Honor.
Mr. Odou, you got final word. It's your motion.
Thank you.
If
Can we
wish
leave
to
the
go.
chart up? Thanks, Mr. Godfrey, appreciate it. Your Honor, what we heard from Mr. Parker is the classic plaintiff response. Defendants didn't work hard enough in taking the deposition of Dr. Zhang. Then, oh no, maybe the defendants worked too hard and they were lying in wait and not asking the question. Neither of those things are true, Your Honor. And it doesn't go to weight, it goes absolutely to admissibility. What the plaintiffs would like to do is they would like to say, look at this chart. Baby Gallagher is there. They want to introduce that evidence in this trial. That's a subject of another motion. Look at Mr. Haley. This is where he was injured. Look at Mr. Belsky. Here's where he was injured. They want to use this to smear real water and say, look at all these people that were injured. Look at the ones that we have in this case. Punish real water, award punitive damages against them, and give us $14 million in compensatory damages. And this is where it becomes prejudicial because we don't have the data points for this graph. And the reason why the data points are important is because we can't say there's a data point in there for the Gallagher baby. We can't say there's a data point in there for Keith Haley, or for Mr. Belsky, or for Myles Hunwardsen in this case, or for Sosa in this case. All we can say is what the report says, which is 18 probable cases. Probable, in our opinion, doesn't meet the scientific standards under Hallmark. Moreover, the bigger problem is plaintiff's expert, Dr. Hudson, doesn't have the data to say, oh, well, this is where this is where that is, nor does he even try. Okay, so what we have is a lay witness who's a qualified lay witness. She's a doctor. Dr. Zhang, and they say, oh, well, you should have asked her. They should have provided the testimony in opposition to this motion or sought permission from this court to reoppose it because they didn't tie it together. It's their burden to show the admissibility of this document. It's their burden to tie in each of these peaks or any of these peaks with a plaintiff in this very case. They want to go outside the four corners of this case. They want to start arguing about plaintiffs in other cases. They want to start talking about the past case, Gallagher. They want to talk about a case they have in the future. That is improper, and that doesn't help them lay the foundation here.
Counsel, I just want a point of clarification, because you said it's their obligation for admissibility of documents, but I thought the issue of the documents.
Admissibility of the argument, excuse me.
No worries, it's making sure if it was changing it.
Yeah, it's the argument. And we're seeking to exclude the argument by way of this motion because you can draw a reasonable inference, but if your expert doesn't close the loop and can't provide expert testimony, then you've got to do it with lay testimony. If you're going to do it with lay testimony, yes, Dr. Zhang, if she had been designated as a non-retained expert opinion or expert doctor to provide a medical opinion of some kind that the injuries of Myles Hunwardsen are consistent with whatever, that would be a different story. All we have is, I'm the author of this report. This is what we did. Here's how we generated this report. They're going to try and lay the foundation for this report. Perhaps it comes into evidence. It seems likely that it will, but maybe it doesn't. We're seeking to exclude the argument proactively because we've seen the arguments already. We've seen how this document is used to smear real water and draw a conclusion that all of these peaks are related to specific plaintiffs in specific cases.
Okay, I appreciate it. Thank you so very much. Here's the court's ruling, document 610, Real Waters Motion Limiting Number 2 to preclude the use of MMWR to argue prior peaks related to real water. The court's going to grant it in part and deny it in part without prejudice. And realistically, we're going to defer in part with regards to, depending on certain testimony that may come in during the trial. The granting of it is without a proper foundation. There cannot be a argument, unless fully supported by applicable case law, that any of these prior peaks are related to real water. In so saying, it's denied in the part that to the extent it is asserted that, well, so Mr. Parker's kind of summary of what he did up at that, look, here's a peak in 2019. Do we have X number of plaintiffs that fall within this same time period? Yes, but can he then say, or whoever's going to be saying it, can the person then say, and therefore these must be real water peaks? Without a foundation, no, that cannot come in. So you need to have a foundation, since I don't know what the 30B6 is going to say and whether or not it's going to tie into certain data points. That's why I said I'm deferring in part. So that's why it's granted in part, denied in part, and deferred in part. It is so ordered. Moving on.